This Honorable Court of Criminal Appeals of Tennessee is now in session.
Good morning and welcome to the December session for the Court of Criminal Appeals in Knoxville. I'd like to introduce the panel this morning. To my left is Judge Kelly Thomas of Maryville. To my right is Judge Robert Montgomery of Kingsport, and I am Norma McGee Ogle of Sevierville. The arguments are limited to 20 minutes per side, and if you would like to save any time for rebuttal, please let me know before you begin your arguments. We are ready for the first case, Mr. Clerk.
State of Tennessee versus Christapher Baumgartner.
Good morning, Your Honors. May it please the court, my name is Garrett Ward, and I'm here this morning on behalf of the state of Tennessee in the matter of State versus Christapher Baumgartner. And if it pleases the court, I'd like to reserve 4 minutes of my time for rebuttal. Thank you. Your Honors, this case arises following the trial court's dismissal of the state's 2-count indictment for vehicular homicide and driving under the influence, which was preceded by the trial court's inappropriate suppression of what is the critical evidence in this case, the results of a blood analysis test performed on a blood draw obtained by the state following the defendant's actual consent to this blood draw. Your Honors, this case is essentially a driving under the influence case. In the early morning hours of the day following Memorial Day, the defendant was driving on a back road in Bradley County when he was involved in a single car accident where he drove off the road and collided with an off-road object. This accident caused the death of his passenger, who was his girlfriend, and caused some injuries to the defendant himself. Following the accident, Your Honors, the defendant was taken to a Nova medical facility, which is where he was encountered by Tennessee State Trooper Eric Diaz, who was sent to the facility to make contact with him following a police report that an accident had occurred. Once at the hospital, Trooper Diaz approached the defendant, who was being tended to by a nurse, and was seated in a hospital bed. Following their initial introductions, where Trooper Diaz informed the defendant that he was a member of law enforcement, the defendant and the trooper had a pretty lengthy conversation with one another about how exactly the accident occurred and what happened between the accident and the moment of their meeting. This conversation lasted, according to the trooper, whose testimony was fully accredited by the trial court in this respect, this conversation lasted for approximately 40 minutes. And during this conversation, the trooper testified that the defendant was responsive to questioning, was responding in an understandable and sensible manner to the questions and comments that the trooper was making to him. Essentially, that he had a fairly normal conversation with the defendant for upwards of half an hour. Now, during this conversation, the trooper did suspect, because the defendant was slurring his words to some extent, the trooper did suspect that the defendant was under the influence of some sort of intoxicating substance. And because of this suspicion, he ultimately sought defendant's consent for a blood draw. When he first asked the defendant if he would consent to a blood draw, the defendant immediately and unequivocally verbally consented to this draw, told the trooper that he didn't have any problem consenting to a blood draw. Following this verbal consent, the trooper went further and read a consent waiver form to the defendant. This form informed the defendant that he didn't have to consent to the blood draw, that if he chose not to consent, that the trooper would not be able to get a blood draw, would not be able to perform any sort of serological testing on a sample of the defendant's blood unless he went and got a search warrant. And it's after being informed of these rights and the ramifications of consent, the defendant signs this form indicating that he once again is consenting to a blood draw. And that's essentially the factual situation in this case.
Wasn't there testimony from the trooper that the defendant couldn't keep his eyes open long enough to do the eye test, and he seemed his train of thought go in and out of consciousness?
Your Honor, the 2 points in response to that. The trooper did say that the defendant was his eyes were sort of narrowed, not fully open during this conversation. So he was not able to complete an HGN test. Regarding his train of thought, the trooper's testimony was not so much that the defendant was all over the place and unable to respond to questions in a normal manner. The trooper's testimony was that the defendant's train of thought continually brought him back to the safety and health of his passenger, who was his girlfriend. At this point, it appears that the defendant was unaware of the severity of the injuries suffered by his passenger that ultimately killed her. So I'd suggest, Your Honors, that the defendant does have some high degree of concern for his passenger, who was a person he was close with, and that during this conversation he is, continually and frequently trying to figure out what exactly happened to his passenger. But I would continue, Your Honor, that the trooper's testimony is not that the defendant is in and out of consciousness or unable to maintain a train of thought. And Your Honors, it's this testimony of the trooper regarding the length and the defendant's ability to sensibly participate in this conversation, which is then followed by multiple expressions of consent, that I contend preponderates against the trial court's ultimate factual finding that the state did not prove consent here. In making this finding, the trial court seems to focus on a concern it has about the contents of an IV that the defendant was receiving and the potential interactions of whatever medications are in this IV with whatever illegal substances were in the defendant's system. What's important to note on this point, Your Honors, is that the trial court specifically finds that it does not know what the contents of this IV are. It specifically finds that there is no proof in the record that these medications would interact with substances otherwise in the defendant's system to produce an intoxicating effect such that the defendant could not voluntarily consent to a blood draw. So what we have here, Your Honor, is accredited testimony of Trooper Diaz that the defendant is sensibly participating in a conversation that lasts between half and 3/4 of an hour. That following this conversation, during which the defendant has been appropriately responding to questions the entire time, that the last question of this conversation is, "Will you consent to a blood draw?" The defendant replies, "Yes." The defendant is then specifically informed of his right to refuse to consent to a blood draw and the ramifications of doing so. And yet again, the defendant expresses his consent to this blood draw. All of this testimony is fully accredited by the trial court. So we have these findings of fact up against this sort of unknown potentiality of what is in this IV bag, to what extent is it perhaps interacting with other substances in the defendant's bloodstream that might ultimately prevent him from giving consent. And Your Honors, I would contend that the factual findings that would support a finding that there was voluntary consent, the length of the conversation, the defendant's ability to participate in it, his multiple expressions of consent, that these preponderate against this concern for the unknown that the trial court has. And Your Honors, as I believe the facts preponderate against the trial court's ultimate factual finding that the state did not prove consent, I contend that the trial court inappropriately suppressed this blood draw because the facts do in fact establish that the defendant actually consented to the blood draw in this case, thus meeting the voluntary consent exception to the warrant requirement. Unless this court has further questions, I'll reserve the remainder of my time.
Thank you, General. Mr. Ridley?
Good morning, Your Honors. Todd Ridley on behalf of the appellee, Mr. Baumgartner. I guess I'd start with the point that the state's argument, once again, seems to mistake its role in this appeal. The state right now is the appellant. It had the burden at the trial court to establish that there was voluntary consent, and it has the burden on appeal to show that the trial court erred. Its reading or its recitation of the facts, while there is some support for some of what the state said, does not take the facts in the light most favorable to the prevailing party. What the state is essentially doing is arguing this case as if it were the appellee and as if it had prevailed below, but it did not. So when the court looks at the record and looks at the transcript, what it's going to find is a set of facts that clearly supports the trial court's decision to find that there is no voluntary consent. For starters, it is what the proof established, and then this is again largely through Officer Diaz's testimony, is that Mr. Baumgartner was in the hospital being treated for major injuries. He was in the hospital, he was connected to an IV, receiving some kind of medication. He could not get up from the bed, he could not perform any field sobriety tests. The evidence established that his speech was very slurred, that he could not hold a train of thought, and that he could not maintain any kind of normal conversation. He even had trouble keeping his eyes open. His signature on this consent form that the state talks about was so illegible that the trial court could barely make it out. Mr. Baumgartner was so impaired that the trooper took it upon himself to fill in the date and time on the form rather than doing what the statute mandates and having Mr. Baumgartner do that himself. So what the record shows, or what the evidence shows when taken in under the appropriate standard of review, is that Mr. Baumgartner was barely conscious and could not give consent. And when the trial court concluded that, it was well within its authority as fact finder to reach that conclusion. And the state has pointed to nothing other than just some speculation about the absence of evidence to suggest that the trial court overstepped its role as the fact finder in reaching that ultimate conclusion. That's kind of the broad overpoints of the case, but I'll come back to a few things that the state did not address. And those are two waiver arguments. First and foremost, the state does not, or the state improperly perfected a Rule 3 appeal in this case. So what we have in this case is, again, a fairly standard driving while impaired type indictment. But there were two blood draws. The result of the suppression order was that the first blood draw was suppressed. The second blood draw was unaffected, nor was any other proof that the state may have had about impairment affected by the trial court suppression order. Under those circumstances, what the state is required, like every other party, is file an application for an interlocutory appeal, or do one under Rule 10 for extraordinary appeal. It didn't do so. What the state did instead was say, well, we don't think we can go forward, so we're going to take a Rule 3 appeal. Rule 3 appeals, though, are reserved for cases where the suppression order truly eliminates all of the state's case. For example, in a drug possession case, if the drugs are possessed, the state really can't go forward. Or in a DUI per se case, if the blood is suppressed, the state really can't go forward. But here, there was other evidence that the state could have used to go forward with trial. It just didn't want to. And that makes what the trial court did a truly interlocutory order. The state could have just taken an interlocutory appeal, which frankly, the trial court seemed to suggest it would have granted. But it can't do what it did, was turn an ordinary interlocutory order into a Rule 3 right of appeal. If taken seriously, what the state is suggesting is that it can take a Rule 3 right of appeal from any adverse ruling whenever it wants, simply by dismissing. That's not what Meeks contemplates. What Meeks contemplates is the state can take a Rule 3 right of appeal when the suppression order truly eliminates the heart of the state's case. That didn't happen here. And so there's no Rule 3 appeal for the state to pursue. For that reason alone, this appeal should be dismissed as improperly perfected. But even if we get past that, there's a second waiver argument that the state has still not addressed. At the suppression hearing, it was fully litigated whether Trooper Diaz violated the statute, and it's 5510-406G, which is no longer in effect, but was indisputably in effect at the time. And that issue, it was part of Mr. Baumgartner's suppression motion. It was litigated at the suppression hearing by both sides, and it was part of the trial court's oral findings and part of its written findings in its order. What the trial court did was said, shall means shall. And what it's clearly referring to in this context is the meaning of the word shall in the statute, again, 5510-406. The state doesn't address that. But what that was an alternative holding by the trial court in support of its suppression order. If the state wants to appeal a suppression order when the trial court has two alternative bases for suppression, it needs to appeal them both. It didn't do that in this case. It focused strictly on consent, but it does not address or even mention the statutory basis for suppression that the trial court relied on and that the parties litigated below. So the state's failure to address that alternative statutory basis for suppression is a waiver of its basis for appeal. So for that is a separate ground for which this court should simply dismiss this appeal as improper or find waiver. But returning to my original point, if the court does make it to the merits, under the standard of review that governs, the facts are clear. And the facts are clear that the trial court had a basis to conclude that Mr. Baumgartner was in no condition to give voluntary consent to this blood draw. And that is because when the officer approached him at the hospital, he was being treated for major injuries. He was receiving IV medication. He couldn't keep his eyes open. His speech was very slurred, according to the officer. He could not hold a conversation at all. And with all of that, the trial court was well within its right to conclude that's not voluntary consent.
Did the trial make specific findings as to what the basis of its decision was as to his ability to give consent?
I would say they're less than full in the context of its final order, but it made some comments about the defendant's condition that would go towards his ability to give consent. And that's what the court can look at in support or to find in support of the trial court's ruling. But beyond that, when the court's looking at the record, it's not looking at it in the light most favorable to the state, which is how the state presented it. The state presented it as if, well, he could keep his eyes open and he was mostly talking about his girlfriend, but it was a sensible conversation. There are other parts of the transcript where it's clear that he could not hold a conversation, where he could not keep his eyes open. And those parts of the record are what the court should focus on under the right standard of review. And that standard of review says, take the facts in the light most favorable to the prevailing party. And that, when coupled with the trial court's factual findings, which again are not as specific as we probably like, but are clear that it is about the defendant's capacity to consent. When you take those things together, I think it's clear what the trial court was doing when it suppressed. But if there are no further questions about that, what we'd ask the court to do is affirm the trial court's ruling either via dismissing the appeal as improperly perfected or by looking at the merits and concluding that the trial court was well within its right as fact finder to conclude that the state had failed to meet its burden of establishing voluntary consent. In that sense, we'd ask the court to affirm. Thank you.
Thank you, counsel. General Ward, you have your rebuttal time.
Thank you, Your Honors. A few brief points on rebuttal. First, regarding the defendant's suggestion that the state does not have a right of appeal in this case, Your Honors, Rule 3 rather unambiguously grants the state a right of appeal following trial court orders that have the substantive effect of dismissing an indictment. We have, in this case, perhaps no more clear example of such an order. We have an actual dismissal order by the trial court that gets rid of the entirety of the state's indictment. It's clear that under Rule 3, following this order, the state would have a right of appeal and does have a right of appeal, and that this appeal should not be dismissed for the state's alleged lack of having a right of appeal. The trial court's order explicitly dismissed the indictment, and Rule 3 clearly grants the state of a right of appeal in these circumstances. Second, Your Honors, the defendant has suggested that the trial court gave some independent basis for, or some alternative basis for suppression, and points to a finding by the trial court that has to do with the implied consent statute. Your Honors, I don't believe the defendant's reading here of the order is correct. The trial court makes 21 findings in its order. At the conclusion of these 21 findings, the trial court says, I'm suppressing the blood draw in this case. The trial court does not, in its order, in any reading of this order, state that, I find the state technically, that there's some technical noncompliance with the implied consent statute, and that this noncompliance with the implied consent statute somehow obviates would somehow obviate other voluntary consent in this case. So I don't believe, Your Honors, it's a reasonable reading of the order to say the trial court's order is that technical noncompliance with the implied consent statute results in suppression of evidence when there's otherwise valid consent. And looking at the trial court's order, it seems clear that the trial court found there was not voluntary consent, and that is its basis for suppression, that it did not identify noncompliance with the implied consent statute as an independent basis for suppression. And Your Honors, to the extent that is what the trial court did, that would be an error. I was able to find no law suggesting that technical noncompliance with the implied consent statute would have a consequence when it comes to the voluntary consent exception to the warrant requirement. And lastly, Your Honors, the defendant has said that the state is asking this court to ignore the appropriate standard of review and to view the facts in the light most favorable to the state. Your Honors, that's not what the state is suggesting here this morning. The state's suggesting that the trial court's own finding that the defendant appropriately responded to questions for 40 minutes and then gave consent on more than one occasion preponderate against its ultimate factual finding that the state did not prove consent here. The trial court explicitly found contrary to the defendant's assertion that the defendant did respond to questions appropriately for 40 minutes. And that at the conclusion of 40 minutes of appropriately responding to questions, that at that point, the defendant told the state that he would consent to a blood draw and that he did so twice. It's in these circumstances, I would suggest that the trial court's finding that the state did not prove consent is preponderated against by the other facts of the case. Your Honors, if there are no further questions, I would ask that you reverse the order of the trial court.
Thank you. This is our second case on the morning docket, and the court would like to thank both attorneys and staff, the AOC staff, our clerk's office, the appellate court clerk, Mr. Hibner, for helping put this together so that we will have it available for anyone who would like to have access to it. It's been very helpful, and we appreciate your assistance. Mr. Clerk, I believe we're ready to recess court.
This honorable court is now in recess until 1 p.m.